Hello class, today's lesson is going to be on Chapter 8, where we're going to be discussing juvenile probation, specifically how it's administered, what are its functions, and what are the roles and responsibilities of a juvenile probation officer. So let's jump in by covering our learning objectives. So the objectives for this lesson are that by the end, you should be able to explain how probation is administered, explain the different functions of probation services, describe how classification and risk needs assessments are used in juvenile probation, describe how we use restitution programs, summarize the various roles and responsibilities of a probation officer, explain the use of intermediate punishments, including intensive supervision programs, describe the use of house arrest versus electronic monitoring, and explain how probation can be revoked as well as the rights of probationers during that process, and finally, to be able to summarize juvenile probation's effectiveness. So what is probation? Probation is a correctional service that allows an offender to remain in the community under supervision by officers of the court. So a non-punitive legal disposition for juvenile delinquent youth, which emphasizes treatment without incarceration. Yes, we do place youth on occasion in the system, but the main emphasis is on treatment. So we have roughly 300,000 youth that are placed on probation every year. This is more than 60% of all juvenile dispositions that are given. So our basic goal here is to provide services to the youth that's going to help them avoid future delinquent behaviors. So probation can refer to four major things. We have probation can be referred to as the disposition in lieu of institutionalization. It can refer to the status of an adjudicated offender, the fact that they're on probation. It's also a subsystem of the juvenile justice system. And it can explain the activities, functions, and services between juvenile court, the offenders, and the community. So how is probation administered? Well, it's either at the local responsibility level or the state or executive level. If it's locally responsible, this means that the citizens and community agencies are going to more readily support it because these programs are open to their participation, that of the community members, and these are usually more responsive to local needs and programs because they're based locally. They're also flexible and less encumbered by bureaucracy that we're going to see in many state and executive controlled probation offices. There's arguments against local administration though. They say that the state can administer a set standard of service, so there's better uniformity across the board, that large agencies can actually make more effective use of funds and personnel, and they have greater efficiency in disposition of resources. So if we look at the state or executive level, they can do things like standardized policy making, standardized recruitment, as well as training, and even personnel management. And again, they may have echelons though of decision making where there's a lot of bureaucracy, so you have just memos being shuffled from person to person and nothing actually being accomplished because there's too many levels of administration that these policies and these recruitment decisions need to go through. So there's pros and cons to both. So what is the function of probation? Well, we have four. There is intake, management of caseloads, supervision and investigation, as well as submitting reports to the court. So in probation, we do use private contractors for intensive probation and aftercare services. For example, you have Nebraska's Family Matters reform, which the goal of was to improve outcomes of youth, community safety, as well as permanency and well-being of children, youth, and families, which we heard about in our last chapter, that whole permanency idea. So we have probation subsidy programs, which are actually used to encourage counties to decrease the commitment of offenders to state institutions and instead place them in local institutions. Then the state will reimburse the county for placing these youth locally rather than committing them to the state level. So it's giving an incentive for these local jurisdictions to remain their youth locally. So if we look here at this graphic, it just shows the different those 4 different items we talked about in relation to a probation officer. We're going to cover all of these. But you'll see, intake is when an officer decides what to do with the juvenile. Then we have supervision, where they're going to be responsible for the behavior of the youth and deciding when and if to violate them for behavior. They have caseload management, so keeping files on the offenders, and providing recommendations to the courts through reports. So let's start with intake. Intake is where the probation officer is going to conduct a preliminary investigation. They're also going to advise youth and their parents of the legal rights that the youth has during that intake hearing. They're going to interview people such as the offender. Typically, the parents will also be at the intake hearing. They call it a hearing, but it's not in front of a judge. It's just usually an intake conference, it's also referred to as. They're going to interview maybe witnesses, victims, the arresting officer or officers. They might even talk to peers, the school or neighbors, just to get a good idea of who is this youth and what are they all about, aside from this act that they committed. They're going to look at prior records and other agency records. So maybe they've been on other community programs before for diversionary, for previous offenses they've committed. They're going to look at those records. And they'll read prior probation or police reports. So if the youth has been on probation before, it's possible that they'll still have the intake conference, but they may end up referring that youth straight to court instead. So then we have management of caseloads. So this is where the probation officer is going to maintain a file, a physical file most times. We also hold them in our juvenile case management system, so it's all electronic, but sometimes it's still good to have that paper copy with you. So they're going to maintain a file on every single juvenile they have. So prior to everything going electronic, this file would be taken with the probation officer to every appointment they had with that youth. On the first time you flip the file, there's a couple pages to the file where you can put your reports, you can put investigations, you can put your case notes, you can keep it all organized. And on one of those you would have your case note, so every time you would go see the youthful offender or meet with a parent or meet with a provider, you would put your notes in there and that's where they would stay. Now that we have things electronically, however, you can still write them in there, but they typically need to be submitted to your secretary to upload them into our electronic system. The positive to having an electronic system is that from anywhere at any time, anyone in probation can access that juvenile's file, because it's all electronic, and see what's going on with this youth. Say we get a detention call for them. We can find out how well they've been doing on probation. If we're on the fence of whether they need to be detained or not, you can use that extra information to assist in making your decision. Say it's midnight, and that probation officer, you're not going to call them because they're not on call. You can get all this information very easily. So this file is going to also include evaluations, psychological, psychiatric, typically drug and alcohol. If it's a sex offender, they'll include psychosexual evaluations. You'll have school records, so not only their grades, but disciplinary records. You'll have their program and service reports from any providers they've been placed on. And during this management of caseloads, we're also going to categorize probationers based on their risk level, so whether they're low, medium, high, or very high. And we'll get into categorization and risk needs at a later slide. But they do say that an effective management of caseloads is going to have smaller caseloads because you're going to have lower recidivism rates when you do that. Because the probation officer is able to focus more clearly and better on those offenders because they don't have just so many that they're worried about just simply seeing for the month. They can actually put their time and effort into it. So then we have the idea of supervision, investigation, and surveillance. This is another function of what probation is for. So the probation officer must establish personal contact with the juvenile. Also, the length of time under supervision is going to vary by state. So for example, in Pennsylvania, we can hold jurisdiction on a youth up until the age of 21, so long as they're placed under supervision and they committed their act before they were 18. It can also be until a youth reaches the age of majority, which is typically 18. And some states actually set the time frame for which a juvenile can be under supervision. So it can be 6 months, 1 year, you might see 5 years. So probation is going to supervise the youth not only at home, but also in their community. They're going to see them at school, and they'll visit them in institutions. They're going to match youth with their appropriate services and programs based on the risk needs assessments that they're going to conduct. So we like to take a balanced approach to juvenile probation. So we have in Pennsylvania called balanced and restorative justice, where you're going to look at 3 factors. You want to protect the community, improve the competency development of the offender, and also hold the offender accountable, particularly if there are victims, so making the victims whole. And again, I know we've talked about evidence-based programs do reduce recidivism, so we want to make sure that we're placing youth on evidence-based programs and not just any old program. So when we look at reports being submitted to the court, you'll have what's called a social study report, which is going to be ordered by the judge in a bifurcated hearing, which we talked about in one of our last chapters. So you're going to have the adjudication hearing and then a completely separate disposition hearing, at which time the probation officer submits a social study report. And it includes everything on the youth that you can think of, from their personal background, their education, present offenses, prior offenses, are they currently working, where do they live, what's their neighborhood like, what are the characteristics of the neighborhood as well as the family, what's the family's financial situation, and what's the physical and mental health of that youth, what's their IQ. And then, once all that is submitted, the probation officer is also going to make a recommendation to the court for whether the juvenile should be placed on probation, whether they need placement, whether we should defer adjudication and place them on a consent decree, what types of services do they need and best match their needs, what programs, what treatment do they require. And a lot of this is also going to be based off of the evaluations that the youth can have. So you can't order evaluations on a youth unless the attorney and the child agree that they can do the evaluations prior to an adjudication hearing. Typically, you have to wait until after the child has been adjudicated as a delinquent, and then evaluations can be ordered. So probation officers are going to use the recommendations of those evaluations in determining which programs are most appropriate for the youth. So we look at how we classify juveniles based on their risks and needs assessments. So categorization is based on the needs and or the risk that they're going to pose to the community. So criminogenic needs are the attitudes and behaviors of the juvenile that lead to or are related to delinquent behavior. So criminogenic needs are the ones that we want to focus on addressing because it's going to have the most impacting change on their future crime. So we have 3 major risk levels here. You have minimum risk level, where you're typically going to contact the juvenile 1 time per month, and every other month you'll have a parental contact. This is not across the board in every state, but this is just a general rule of thumb. In moderate cases, you'll typically see the youth maybe twice a month, and one of those visits needs to be with the parent. Again, it's very important that the parent is involved and is being included on everything that's going on, because typically the youth isn't even going to tell the parent that you met with them. I can't tell you how many times I called a parent after I maybe met with a youth at school, and the parent says, "Oh, they didn't even tell me you came to see them." You also never, as a probation officer, want to get into court and have a parent sit there at a review hearing and say, "I don't know who that person is. I've never met them. That's their probation officer. I don't know them." And it has happened. So you want to make sure that does not happen. Everyone needs to be on the same page and have great communication. Not always easy, but you need to. And then you have your high-risk youth. So these are typically going to be seen 4 times a month or weekly, and usually have 2 parental contacts per month. Again, very important for your high-risk kids. Are typically going to be on a lot of programs and services, so they're going to be seen a lot. But it's because we want to make sure that we're keeping on top of them, and making sure that they're doing what needs to be done. Our minimum and our low-risk youth, we don't want to see very often, because you can actually increase recidivism in a low-risk offender if you see them too much and have too much contact with them. So restitution programs. Certain youth, typically when there's a victim involved, will be required to either pay financially to the victim, complete community service, or complete direct service to a victim. That last one doesn't happen very often, but it has been known to happen. So the probation officer's responsibility in this, there's a few. They can have the responsibility of determining whether the youth is eligible to participate in certain community service programs, calculate the amount that's owed to a victim if they're requesting financial reimbursement, assess the offender's ability to pay the amount that the victim is asking for, help develop a payment plan or a work schedule with the youth for how they're going to either pay off the fine and restitution or how they're going to complete community service to satisfy that. Most counties have a program where the youth can complete community service hours in lieu of making financial payments, and typically the youth will be paid anywhere from $8 to $10 an hour, and that will get credited towards their restitution. So it's either a program that's paying that, or it's coming out of things like a restitution fund that other offenders pay into. And then the probation officer is also just going to monitor the performance of that juvenile and making sure that these are being completed. So a lot of counties have work crews. So these programs are usually run by probation officers, and they'll actually take a few youth out into the communities, going to parks, libraries, nursing homes, YMCAs, various community centers, and even some SPCAs. They're going to go out to these facilities and they're going to have the youth do work. So they need to make sure that they're being supervised, which is why a probation officer goes with them. So we talked about some responsibilities of a probation officer there, specifically with restitution programs, but what are some other roles and responsibilities of a PO? Well, they have two major roles. You have law enforcement and a treatment role, which together create a role conflict. So you have a probation officer who's at one time trying to enforce these court orders, enforce the law on a youth, even having to handcuff them and detain them, but then also having to play this treatment role and work on skill building with them. And your book will talk about how it's very hard sometimes to switch between these two roles, and it's hard to get the youth to trust you. The biggest thing I can say is honesty. I only had one youth one time fight me trying to detain him, and it's because he was high on drugs. Every time I went out to detain a youth and every time I had to take on that law enforcement role, because I'm definitely geared more towards a treatment role, they knew it. They were expecting it because I was honest and upfront with them. I told them, if you do these XYZ actions, here's going to be your consequence. I was always swift and certain in those consequences, so they knew to expect it. It's very important. I was still able to work. I mean, I had youth that I detained numerous times, and they would still sit and talk with me. Had one kid, he was great. His family actually ended up coming to my church then, but he was, I want to say maybe 6 foot tall. I'm 5'3". He's maybe 230. He was a big kid. Never had an issue detaining him. I would say, hey, I came to school one time. I said, you know why I'm here? He's like, I know. I'm sorry, Miss Brianna. I know I went out last night and I wasn't supposed to. I said, okay, I'm going to need to detain you. Are you going to give me an issue? No, I know I messed up. Okay. Pulled everything out of his pockets for me and turned right around to be handcuffed. No issue. Again, just being honest with the kids. It's not always going to happen. You're not always going to have those great stories. Sometimes they're still just going to be pissed. But at the end of the day, as long as you're honest with them, they really do have a tough time staying angry with you because they knew it was coming. So let's get back to these roles and responsibilities. So it's also important that they remain knowledgeable as a probation officer about new developments in research on the behavior and cognitive development of children and adolescents so that we can better understand why are the youth of this generation acting in this way. They also act as brokers of services, so I know we talked about this when we met on Wednesday, but they'll also be responsible for making referrals to outside agencies and other programs that's going to best meet the juvenile offender's needs. So with some other responsibilities we have listed here, they're responsible for paperwork, having contact with the juveniles, writing reports for court, detaining and transporting the youth, enforcing court orders, and like we said, making referrals. So they have a lot of responsibilities and a lot of different hats that they wear. So let's get into intermediate punishments. So these are things such as intensive supervision programs. The next slide, we're going to talk about house arrest and electronic monitoring. These are anything between probation and placement. So intensive supervision programs, you're going to place your most high-risk offenders on small caseloads where they're going to have very frequent contact with their JPOs. So the idea is that you have increased contact, increased surveillance, you're increasing the external control over the youth. And this one wasn't mentioned quite clearly in your book, but you have to also have increased treatment with that. Simply having increased surveillance and increased contact, all you're going to do as a probation officer is find more violations, find more rule breaking, because you're having more contact with the youth. So you have to make sure that you're also meeting them with increased treatment. Typically, they say you should have caseloads of less than 15 youth, a minimum of 3 contacts per week, 1 parental or guardian contact per week, and the supervision term is typically going to be between 6 to 12 months. I know for our office, for felony offenders, we require at least 12 months of supervision, or between 9 and 12 months before they're going to agree to allow the youth off of probation. So now, what's the difference between house arrest and electronic monitoring? Well, approximately 20% of offenders are currently monitored at home. House arrest is when a youth must remain confined to their home, so they're arrested to their home. Electronic monitoring, however, tracks a youth through electronic devices, typically monitored in some fashion 24/7 around the clock. So we have examples such as identity verification. You can have ignition interlocks, which will be placed on the offender's car. And we do have some youth, because they're of driving age, that will get these. And they have to blow into the system and show that they're not intoxicated to be able to start the car. We have victim notification systems and our global positioning systems, or GPS, which is going to be your most common. The goals of electronic monitoring are that we're increasing the number of youth that can safely be released to their homes and safely stay in their homes and in their communities. We reduce the number of youth that are being returned to detention for violations. We can reduce the number of field contacts that a PO has to make because they're able to see where that youth is. So rather than having to go out to little Johnny's home and make sure that he's in his home, we can just see that he is through the monitor. We can have earlier reunification and a better return to school. So when we revoke probation, youth have a few rights. They have the right to have a hearing, a right to a 5-day notice of that revocation hearing being scheduled, the right to confront any witnesses, and the right to see reports citing the violation. I did have a youth who did this. He contested his violations. His violations were that he was not going to school. I believe we had 2 dirty drug screens on him, and he was failing to participate with a program. So, violated his probation, gave him a couple chances before we did this, but he wasn't amenable to anything that I tried to put in place. So we bring him into court. He contested. We actually held a hearing. I had to testify. His academy worker, who is someone who does an aftercare service for us and sees the youth more frequently, had to testify. The judge ultimately found that he violated. And an interesting fact about that, he actually has since, just as recently as this last week, he's been released off as of 2 years ago. He's now been arrested on sexual offenses as an adult, and it was just on the news. So sometimes you can do your best and you can do everything you think that you can do in juvenile probation, and some youth are just not amenable. I know some of you are on your final projects are talking about family circumstances. The youth did not talk to either of his parents, and he was actually living with his adult sister at the time I had him on probation. So he pretty much had free reign to do whatever he pleased. Another point to note with that is that this is the reason why I, as a female probation officer, and even as a male, it's a good practice to see youth with another probation officer, to never go out to a home alone, because you never know what that youth could potentially be capable of, and you don't ever want to put the youth in a position or give them the opportunity to commit any type of crime, whether it would be to steal from you, to rob you, to commit a violent act against you. It's always good practice. So I feel safe knowing that I'd always taken another male with me when I went to see him. So there's 2 important court cases here that I want you to know. We have Mempa v. Ray, which said that Sixth Amendment right to counsel applies to sentencing hearings. Then we have Gagnon v. Scarpelli. So in the adult system, they actually call violations gagnons, and it's from this case. So it says that counsel should be provided, so a defense attorney, should be provided to the probationer when the probationer denies that they committed the violation or when the reasons for violating are complex. So that one's a little more vague, but essentially we're saying if it's not clear, cut and dry about the violation, then we should make sure they have counsel that can argue on their behalf. So how effective is probation? Well, it's more effective than any other method of rehabilitation. We have a large number of offenders that are incarcerated that could be placed on probation without increases in recidivism. Probationers have lower violation rates than parolees, and intensive supervision has been associated with lower recidivism rates in youth. Juvenile probation is most effective when we use risk needs assessments to make our decisions, and also when we make referrals to community-based programs. We need to make sure that we're following graduated sanctions and graduated responses, which is meeting the youth and their violations or their crime with an appropriate level of punishment. And then our program, we need to make sure that we're reviewing and evaluating our programs. So in my office, we have the quality assurance unit, which I'm the supervisor of, and our job and my unit's job is to make sure that both our community-based and our residential providers are providing the services they say they're going to, and that they're providing those programs at an appropriate level to meet our youth's needs. So just a few points on the different aspects of being an effective probation officer. So someone who's effective is going to be able to build genuine relationships with their probationer. They generally treat others with respect, kindness, and compassion. They're not gullible or easily swayed by a youthful offender. They're positive and encouraging of others. They have a good sense of self-awareness, so they understand themselves and their own faults. And they have to be committed to the job. You're not going to make big money doing this, so you have to really want to help youth. In sum, probation can be administered locally, state or executively, or a combination. Probation allows offenders to remain in the community while receiving services. We use risk needs assessments with classification or to assist with classification of probationers. Probation officers have a number of responsibilities, including intake, caseload management, supervising and investigating, and also writing reports. Intensive supervision programs are a form of intermediate punishment because it's between probation and placement. Restitution can be a court-ordered disposition that requires the juvenile to pay back the victim in some fashion. House arrest is going to confine a youth to their home, while electronic monitoring tracks the offender. Probationers do have certain rights during a revocation hearing, and probation is effective at reducing recidivism while also providing supervision of offenders. So that was your Chapter 8 lesson. Please let me know, shoot me an email, give me a call if you have any questions on any of that.